Diana gave up everything. Not metaphorically, literally everything. She quit her job, she sold her apartment, she moved into her mother's house. Full-time caregiver, no salary, no days off, no end date. 3 years. Her mother had vascular dementia. Someone had to be there. Diana was there. 6 weeks before her mother died, her sister flew in from Denver. Linda stayed 3 weeks. She said she wanted real time with their mother. Time that still mattered. When the will was read, Diana's name was gone. Not reduced, not adjusted, completely removed. $1.35 million. The house, the savings, every investment, all of it to Linda. Every dollar Diana had sacrificed 3 years to protect, taken. Diana had no idea the betrayal was coming, but the evidence was already inside her house. She had placed it there 18 months earlier. She did not know what it had captured until she went looking. Diana had always been the closer daughter, not because Linda was a bad person. They got along. They called each other twice a month. They met for most holidays. But geography shapes family over decades. It shapes who shows up. It shapes who knows the details. It shapes who gets called first when something goes wrong. Diana lived 40 minutes from her mother's house in Naperville, Illinois. Linda lived in Denver. That distance, year after year, decade after decade, became a different kind of fact about who each daughter was to Margaret. Diana noticed first. She was the one who drove Margaret to the GP. She noticed her mother repeating questions she had already asked that same morning. She sat in a neurologist's office in November 2022. She heard the words vascular dementia. She understood what they meant for everything that came next. Margaret was 82. On good days, she was still herself. She knew every name. She laughed at the same jokes. She told the same story about meeting Diana's father at a bus stop in 1966. Same words, same pause, same punch. But good days were going to thin out. The neurologist was honest about the direction. Diana drove home. She sat with a glass of wine she didn't drink. She thought through what came next. She was 48. She had a solid career. Marketing director at a mid-sized logistics firm. Remote capable, a team she had built herself over 6 years. For a while, remote work made the caregiving manageable. She drove to Naperville twice a week. She called every morning. She built a medication tracker. She made an emergency binder. She hired a part-time aide 3 days a week. Then Margaret fell the first time, then a second time. Then came the 2 a.m. call. Her mother was confused about where she was. She did not recognize the aide sitting beside her. In January 2023, Diana told her manager she was leaving. She did not call it a leave. She understood what she was choosing. She sold her Lincoln Park apartment, a 1-bedroom she had owned for 9 years. She moved into Margaret's house in Naperville. She became Margaret's full-time caregiver. No salary, no timeline, no plan for going back. She told herself, as long as it takes. Those 3 years were not romantic. There was nothing noble about 3 a.m. alarms, nothing graceful about the paperwork, nothing peaceful about watching a person's mind recede week by week while you document every change in a binder. Diana did not complain. She did not seek credit. She understood what the work was. She did it. She gave up salary. She gave up her social life. She gave up the physical space that was her own. She gave up the ability to make plans beyond the next week. She gave up the version of her 40s she had imagined. Every one of those sacrifices was a choice. She made each one willingly because she loved her mother and because someone had to be there. Linda called to say it was a beautiful thing to do. She asked if Diana needed help with moving costs. Diana said no. She thanked Linda for asking. Over the next 3 years, Linda visited 4 or 5 times a year. Long weekends, a full week at Christmas. She was warm when she arrived, present with Margaret, good at the easier hours, old television shows, photo albums, afternoon conversations. She contributed $400 toward a hospital bed when Margaret needed one. She talked about wanting to visit more. She meant well. Diana believed that without reservation. But Diana had confused good intentions with trustworthiness. Those are not the same thing. But it gets worse. And the worst part did not begin in a courtroom. It began in the months Diana spent believing her sister was finally becoming someone she could rely on. 3 years in, Diana's life had reorganized entirely around Margaret's schedule. 6 a.m., medications, breakfast. Morning, physician calls, insurance paperwork, pharmacy runs, equipment maintenance. Afternoons were Margaret's clearest hours. Familiar television, old photographs, wandering conversations that still carried real warmth. Evenings, dinner, second round of medications, the patient work of helping Margaret settle for the night. Then Diana would sit at the kitchen table alone for 20 minutes. She could not sleep any earlier than that. She had learned her mother's dementia the way you learn a language, imperfectly at first, then fluently, then without thinking at all. She could read Margaret's face from across a room. She knew which sounds were confusion and which were distress. She knew the difference before Margaret said a word. She also believed she understood the estate. Margaret's will had been drafted in 2019, the last year Margaret was fully herself. Patricia Wills was the attorney, a woman Margaret had trusted on every legal matter for 15 years. The document was simple and clear. The estate split 50-50 between Diana and Linda. The Naperville house was assessed at $840,000 in 2024. The savings account held approximately $320,000. The investment accounts totaled around $190,000. Total, $1.35 million, half to each daughter. Diana had read the document. She was present when Patricia explained it. She signed as a witness alongside Margaret's neighbor and accountant. She did not think about the will again after that. The plan was settled. There was nothing to think about. That certainty, that belief that the most important thing was handled, is precisely what the betrayal was designed to exploit. In year 3, Linda began visiting more. The shift was gradual, an extra long weekend in March, 2 full weeks in July instead of 1. She told Diana she had remote flexibility now. She said she felt guilty. She wanted to carry more weight. Diana was glad to hear it. She was tired in a way sleep did not fix anymore, the kind of tired that settles into the body when care becomes the whole of someone's days and nights. Linda started attending some of Margaret's GP appointments. She took Margaret to a couple herself to give Diana a break. She asked questions about medication interactions, about what the later stages of vascular dementia looked like, about how Diana managed the harder days. "Stay with me." Diana described it to a friend on the phone. She said Linda finally got it. She said Linda finally understood what this actually was. She was not wrong that Linda had come to understand something. She was wrong about what? Diana would later trace the shift in Linda's behavior back to a specific month. She would identify the pattern. More questions about the estate. More interest in paperwork she had never asked about before. More time alone with Margaret on the afternoons when Diana ran errands. She did not notice the pattern while it was forming. She was too tired. She was too grateful. She was too relieved to have someone else in the house. That is how it works. The person doing the most is also the most vulnerable. They are tired. They are trusting. They believe the person beside them is there for the same reason they are. In February 2026, Linda called. She had arranged 3 full weeks of remote work. She wanted to be present, not just visiting, but actually sharing the load. Diana felt something loosen in her chest. She made quiet plans. Sleep past 6 a.m., a longer walk, a call to a friend she hadn't spoken to in 2 years. Linda arrived on a Thursday. The first week went well. Linda handled the morning medications twice. She managed a difficult afternoon when Margaret couldn't place Linda's face and became frightened. She was patient and steady. Diana thought, "This is real. Something has actually shifted." The following Tuesday, Diana had an appointment she could not reschedule. A medical supply company in Downers Grove, 35 minutes away. A replacement bed railing. 2 transfer belts. 2 hours at most. She texted Linda before leaving. Linda replied, "Go, we're fine." Diana came home to a quiet house. Margaret was napping. Linda was reading on the couch. Nothing looked different. Diana put the equipment away. She made tea. She asked if anything had come up. Linda said no. Quiet afternoon. Diana had no reason to ask anything further, so she didn't. And here's what they didn't know yet. Neither Linda nor James Hollis knew about the cameras. Not because Diana had hidden them. She had told everyone. The home health aides, Margaret herself, every regular visitor. But Linda had been so focused on what she was planning that she had not stopped to ask what Diana had installed in that house over 3 years of caregiving. She had not asked about the cameras. That was the only mistake Linda made. But it gets worse. Over the following 6 weeks, Margaret's dementia progressed sharply. More confusion, more fear in the evenings. Diana increased monitoring, adjusted medications, added home health support a third day each week. Margaret died on April 14, 2026, peacefully. Her own home, Diana beside her. Linda arrived the next day. She arranged the flowers. She called the relatives. She stood beside Diana at the memorial. She told everyone Diana had given their mother the greatest gift anyone could give. 3 days later, Diana called Patricia Wills to begin probate. Patricia asked, which will did she have? Diana said, the 2019 document, the 50-50 split. Patricia said there was a newer one, executed February 10, 2026, 5 weeks before Margaret's death. Linda was the sole beneficiary. Diana did not speak for several seconds. Then she asked who had drafted it, a name she did not know, a firm she had never heard of. Not Patricia, not anyone connected to Margaret, to Naperville, to any part of their family's legal history. A Denver address on the letterhead. Diana requested the full 2026 will that afternoon. When it arrived, she went through it carefully. The language was standard. The structure was clean. 2 things stopped her. First, the signature. She had watched Margaret sign her name hundreds of times. Birthday cards, insurance forms, the 2019 will she had witnessed herself. She knew the shape of that handwriting. The 2026 signature was smaller, compressed, pressed harder into the paper, like someone holding a pen with effort rather than ease. Second, James Hollis. She searched his name. Solo practitioner, licensed in Illinois but based in Denver. No estate law background anywhere in his public profile. His practice covered commercial leases and small business contracts. Nothing about wills, nothing about estates, nothing about cognitively vulnerable clients. She wrote down the Denver connection. She set it aside. And here's what they didn't know yet. Diana had installed 4 security cameras inside Margaret's home 18 months earlier. Standard dementia care practice. Safety, not surveillance. Motion triggered, cloud stored, 90-day rolling archive. Cameras at the front entry, the living room, the kitchen, and the hallway outside Margaret's bedroom. She had told Margaret. She had told the home health aides. She had told everyone who came through regularly. She had never thought of those cameras as anything other than a tool for catching falls. She pulled the archive for February 10th. At 2:14 p.m., 14 minutes after Diana left for Downers Grove, a car parked in front of the house. A man in his mid-50s stepped out. He carried a leather briefcase. Linda opened the front door before he reached the porch. They did not greet each other like strangers. No introduction, no handshake. She stepped back. He walked in. They moved directly to the dining table. Linda brought Margaret from the sitting room. Margaret sat. The man placed documents on the table. Diana watched 41 minutes of footage. She watched it 4 times in a row. Stay with me. The pattern was consistent from the first minute to the last. The man would ask Margaret a question. Margaret would pause, then she would turn, not toward him, but sideways toward Linda. Linda sat just outside the camera's direct frame. Margaret would wait. Linda would give a small nod, barely visible. Then Margaret would answer, 11 times. Diana counted. At 2:49 p.m., the man placed a document in front of Margaret. Margaret looked at it. She looked at Linda. She leaned forward and said, the microphone caught it clearly, "Is this right, Linda?" Linda nodded. Margaret signed. The man closed his briefcase. Linda walked him out. He drove away. Linda came back to the dining room. Margaret sat at the table looking at the wall. Diana called a probate litigation attorney the same day. She did not call Linda first. She did not call any family member. She did not sleep on it or wait to see how she felt in the morning. She understood what she had seen. She understood what it meant. She understood that every hour she waited was an hour the other side had to prepare. She had watched her mother look to Linda for permission to sign her own name. She had counted it 11 times. She had the exact moment on video. She had the timestamp. She had the face of the man with the briefcase. She called Rebecca Alcott at 7:42 p.m. on a Tuesday night in April. She had not eaten dinner yet. She did not care. The attorney Diana hired was Rebecca Alcott. 19 years of probate litigation, based in Chicago. Diana sent the footage that night. Rebecca watched it and called back within the hour. "We need to know who James Hollis actually is," she said. "That's the first thing we find out." The answer came quickly. James Hollis, solo practitioner, Denver, Colorado, licensed in Illinois since 2001. No disciplinary record in either state. Primary work, commercial leases, small business contracts. No estate law background. No prior connection to Margaret. No prior connection to the family. No prior connection to Naperville or to anyone involved in Margaret's care. And Linda's college roommate. 4 years. University of Colorado, Boulder, 1991 to 1995. He had never disclosed that relationship, not to Margaret, not in the document, not to Patricia Wills, not to Diana, not to anyone. He had never met Margaret before February 10th. He did not review her medical records. He did not review her dementia diagnosis. He performed no assessment of her cognitive capacity. He drove from Denver. He spent 41 minutes. He executed a document transferring $1.35 million from 2 daughters to 1. He left. The betrayal was not impulsive. It was arranged. And here's what they didn't know yet. Linda had made one error. She had not asked Diana what was installed in that house. She had not asked because she had never thought to. That single oversight, that one question never asked, was the crack in an otherwise careful plan. But it gets worse. Linda learned through a family contact that Diana was considering a legal challenge. She called 4 days after Rebecca filed the initial probate challenge. The call lasted 6 minutes. Linda said Diana was twisting a grieving woman's final wishes. She said Margaret had been completely clear about what she wanted. She called Diana bitter. She called Diana ungrateful. She said Diana was making her mother's death about money. She did not mention the cameras. She did not mention February 10th. Diana let her talk. Then Diana told her the challenge was filed, that she had 41 minutes of video, that the video had audio, and that she would see her in court. Linda hung up. 2 weeks later, the bank records arrived. In the 11 days between Margaret's death and the opening of formal probate, Linda had made 4 withdrawals from Margaret's primary savings account. Total, $47,000. The account held Margaret's name only. Diana pulled the co-signatory records. Linda had added herself quietly in January 2026, 1 month before James Hollis arrived with his briefcase, 1 month before the Tuesday, 1 month before the 41 minutes. Diana forwarded everything to Rebecca that same afternoon. The probate challenge required Linda to produce all documentation related to the 2026 will. James Hollis received a subpoena for his complete client file, every note, every intake form, every document generated in connection with February 10th. The file arrived 3 weeks later. Rebecca called Diana the morning she received it. "I want to read you one line," she said. "Just one line. From his own file. Stay with me. Before any legal engagement, an attorney completes an intake form. Standard practice. Mandatory. The form documents what the client, the person whose estate it is, has stated as their own intention. It is the foundational proof of independent representation. It is the record that the testator, not someone else, directed the engagement." James Hollis completed such a form before February 10th. Under client's stated wishes, in his own handwriting, he wrote, "Beneficiary change. per L. Not per Margaret, per L. 4 words, in his own file, in his own handwriting. He had summarized the entire purpose of a $1.35 million estate transfer as an instruction from a third party, not from the woman at the table, not from the person whose signature would appear on the document, from Linda, the person who had called him, the person who had opened the door. He recorded the deception himself, in his own file, under her initial. Diana did not respond when Rebecca finished reading. Rebecca waited. "He wrote it himself," Diana said. "He wrote it himself," Rebecca confirmed. That 4-word note, combined with the footage of Margaret asking, "Is this right?" before signing, completed the case. Linda had not just influenced her mother, she had directed the outcome. Hollis had received the instruction. He had carried it out. He had then recorded it under her initial in his own client file. Rebecca told Diana, "In 19 years of probate litigation, I have never had opposing counsel hand me a case this clearly." The hearing was set for September. The probate court hearing ran 2 full days. Rebecca submitted the camera footage to the court in full. She submitted the intake note as a separate exhibit. 3 of Margaret's treating physicians provided written assessments of her cognitive state in February 2026. All 3 reached the same conclusion. Margaret retained intermittent legal capacity, but she was highly susceptible to suggestion. Her dementia had progressed to a stage where she consistently looked to trusted people for guidance on decisions she could no longer evaluate independently. This is a documented neurological consequence of advanced vascular dementia. It is not a character failure. When the brain's decision-making pathways degrade, the mind seeks external signals. It reads faces. It waits for nods. It defers to proximity and trust. Linda's attorney argued that Margaret appeared calm during the signing, that she answered questions, that she had exercised her legal right to change her will. Rebecca played the footage. But it gets worse. The court identified 3 independent grounds for invalidity. Ground 1, undue influence by Linda. The evidence showed Linda directed the outcome. The instruction came from her. The attorney was hers. The timing was her construction. The betrayal was deliberate and structural. Ground 2, failure of independent representation. James Hollis carried an undisclosed material conflict of interest. He could not represent Margaret's independent interests. An attorney who takes instruction from a beneficiary does not represent the testator. That is a foundational violation. Ground 3, no capacity assessment. Hollis performed no independent evaluation of Margaret's cognitive state. Given her documented diagnosis and her physician's records, that assessment was required by law. Hollis did not conduct it. He arrived. He spent 41 minutes. He left. The court struck down the 2026 will in full. The court reinstated the 2019 will as Margaret's valid final document. Diana received her 50% share, $675,000 after the house sale, savings distribution, and investment accounts. The court ordered Linda to repay the $47,000 taken from Margaret's accounts after her death. Linda paid the first installment 3 months after the ruling, after a sanctions warning. She completed the balance over 14 months. And here's what they didn't know yet. The state bar proceeding that followed the civil case extended further than anyone anticipated. The Illinois Attorney Registration and Disciplinary Commission held a full disciplinary hearing for James Hollis. The panel cited 3 violations: failure to disclose a conflict of interest, failure to assess cognitive capacity for a client with documented dementia, documentation practices below the professional standard of care. The commission suspended his Illinois license for 18 months. His Colorado license remained under separate review. Diana does not call the outcome a win. She calls it getting back what was already mine after someone decided I didn't deserve to have it. She did not return to marketing. She now works with a Chicago area nonprofit helping family caregivers navigate estate disputes. She keeps 2 archived copies of the camera footage on 2 separate drives. Let's talk about what happened here, not just legally, psychologically. There is a concept in both law and behavioral science called undue influence. It has a precise definition. It is not ordinary persuasion. It is not a hard conversation. It is the substitution of one person's will for another's. The exact point where the decision being made no longer belongs to the person whose name is on the document. Undue influence does not require force. It does not require threats. It requires two things: a relationship of trust and a vulnerability in the person being deceived. Margaret had both. She trusted Linda completely, the way a parent trusts a child who has given them no reason to doubt. And her vascular dementia had progressed to the point where she looked to trusted people for signals about what she should decide. This is not a character flaw. This is a documented clinical pattern. When the brain's decision-making capacity degrades, it does not simply stop. It outsources, it reads faces, it waits for nods from the people it trusts. Linda understood this. She built a plan around it. Months of observation, an attorney she already controlled, a visit timed for prolonged access, a Tuesday window she had identified and waited for. A 41-minute meeting while Diana was 35 minutes away buying a bed railing. This was not impulsive. It was structured. The betrayal was engineered across months. Here is what I want you to carry from this story. If you are a caregiver, if you are the person who shows up, who gives things up, who is present day after day, your presence is a form of legal protection, and your absence, planned or not, creates a window. A window someone else may choose to use. That is not a reason to never leave the house. It is a reason to understand what can happen during the hours when you are gone. These are warning signs worth knowing. A family member who was previously distant, becoming unusually present during a loved one's medical decline. Legal meetings scheduled during your absence. An attorney with no prior connection to your loved one, especially one connected to another family member. Signatures that look different from your loved one's usual handwriting. Financial account authorizations added quietly in the months before a death. Documents dated during a window when you were not home. None of these, alone, is proof of anything. Together, they form a pattern that is far easier to investigate early than to untangle after a will has been read. If you are the primary caregiver in your family, document everything, not because you are suspicious, because documentation is the baseline of protection when you are the person making the most sacrifice. Keep copies of legal documents. Know the name of every attorney connected to the estate. Know when accounts are accessed. Know who visits during the windows when you are away. These are not acts of paranoia. They are acts of self-protection by the person the system most often forgets. Caregivers are the invisible infrastructure of families in crisis. The legal system does not automatically protect them. Courts do not assume that the person who gave the most should receive the most. That protection has to be built. It has to be documented. It has to be asserted. Diana built it accidentally. The cameras were for safety. The archive was routine. She never planned to use them in a courtroom, but she had them. And that made the difference between losing $135 million and recovering $675,000.